Before we begin, a quick and important disclaimer. The historical trends, data analysis, and case studies presented in this video series are for educational, informational, and entertainment purposes only. This content does not constitute legal, financial, tax, or psychological advice. Divorce laws, asset distribution regulations, and custody frameworks vary significantly by state jurisdiction and historical era. Viewers should conduct their own due diligence and consult with licensed professionals, including family law attorneys and certified financial planners, before making any decisions related to these highly sensitive topics. In 1980, the United States reached a staggering demographic tipping point that sent shockwaves through the cultural, economic, and political institutions of the nation. For every 2 marriages performed that year, approximately 1 ended in dissolution. This peak was not a sudden accident or a temporary cultural anomaly. It was the explosive culmination of a 200-year evolution in how the American legal system, economic landscape, and social fabric defined the boundaries of human commitment. Imagine standing in an American suburb in the late 20th century, looking down a typical street, and realizing that half of the wealth, half of the households, and half of the family structures were undergoing a systemic re-engineering. Yet, if you look at the data today, a completely different and deeply misunderstood trend is unfolding. The divorce rate in America has actually been steadily declining for decades, reaching lows that haven't been seen since the early 1970s. This creates a profound historical paradox. Why did marital dissolution skyrocket to a historic peak in the late 20th century, and why is it dropping now? The answers to these questions are not found in simple cultural arguments about morality or commitment. Instead, they are buried within a secret demographic map of socio-economic shifts, legislative revolutions, and changing economic realities that dictate the trajectory of modern relationships. To truly understand how we arrived at this modern landscape, we have to look past the contemporary headlines and examine the invisible demographic currents that have quietly shaped the American household since the founding of the Republic. Historically, the journey of marital dissolution was not merely a private emotional tragedy. It was a highly regulated, deeply politicized bureaucratic battleground. In the colonial era and the early days of the United States, particularly within the Puritan settlements of New England, marriage was uniquely defined as a civil contract rather than an immutable religious sacrament. This subtle distinction laid the groundwork for a uniquely American approach to separation. Yet, for nearly 2 centuries, obtaining a formal dissolution required a literal act of the state legislature or absolute proof of severe, catastrophic fault, such as abandonment or physical cruelty. Couples seeking to dissolve their unions had to orchestrate elaborate legal charades, present manufactured evidence of infidelity, or migrate to distant jurisdictions. Long before Nevada became the epicenter of quick divorces in the mid-20th century, states like Indiana and Utah in the 19th century operated as early historical divorce mills, attracting affluent individuals who traveled across state lines to exploit lenient local statutes. The historical data tells a story of immense pressure building behind a dam of legal restrictions. When that dam finally broke with the introduction of no-fault legislation in the late 20th century, the floodgates opened, transforming the economic trajectories of millions of citizens and creating a completely new demographic profile for the typical American life cycle. This deep dive masterclass is designed to solve a fundamental problem that faces every single adult navigating the modern American landscape: the profound misunderstanding of how structural forces, rather than personal failures, drive marital longevity and dissolution. By examining the demographics of the typical divorce journey across U.S. history, this series equips you with an analytical framework to understand the hidden socio-economic variables that influence modern partnerships. We are stripping away the emotional rhetoric and examining the cold, hard historical trends, exploring why certain generations, income brackets, and geographic regions experience radically different potential outcomes. Understanding this history is essential because the financial, legal, and social structures governing modern relationships were forged in the crucible of these past demographic shifts. Consider the critical variable of socioeconomic status and educational attainment. Historical trends reveal a profound divergence that began to accelerate in the late 20th century, creating what sociologists refer to as the marital divide. Individuals with a college education have seen their statistical stability rise significantly over the past few decades, while those without higher education face a completely different set of structural pressures. We will dissect the exact mechanics of this divide, investigating how shifting labor markets, wage stagnation, and changing expectations of gender roles within the household created a volatile environment for working-class marriages. We will examine historical case studies from industrial manufacturing hubs to rapidly expanding metropolitan areas, illustrating how macroeconomics directly dictates the microdynamics of the family unit. This masterclass will show you exactly how financial security, or the lack thereof, alters the statistical probability of a union's survival, transforming how we view the intersection of love and capital in American history. Furthermore, this series tackles the geographic anomalies embedded within the American landscape. It is a common misconception that traditional, culturally conservative regions maintain the lowest rates of marital dissolution due to shared societal values. In reality, historical data consistently reveals that the American South, often referred to as the Bible Belt, has historically experienced some of the highest rates of divorce in the country, while the more secular Northeast has consistently maintained the lowest. We will unpack this paradox step by step, analyzing the intersecting demographic factors of early marriage age, lower average household income, and distinct regional economic policies that contribute to these unexpected potential outcomes. By mapping out these regional variances, you will see how local economies and cultural timelines exert a powerful unseen influence over personal domestic outcomes. We will also confront the rapidly growing modern phenomenon known as gray divorce. While overall rates of marital dissolution among younger generations have actually stabilized or decreased over the last 2 decades, the rate for adults over the age of 50 has dramatically doubled since the 1990s. This shift represents a massive demographic realignment with profound implications for the American economy, particularly regarding healthcare infrastructure, social security systems, and the liquidation of multi-generational wealth. We will explore how longer life expectancies, the financial independence of women entering the workforce in unprecedented numbers during the mid to late 20th century, and changing cultural perceptions of fulfillment in later life, have converged to redefine the final chapters of the typical American family journey. Throughout this 10-part masterclass, we will not merely list statistics. We will trace the precise historical evolution of custody arrangements and asset division. We will examine how the American legal system moved from an era where children were legally considered the financial property of their fathers, to the maternal presumption of the tender years doctrine, to the modern landscape of joint legal and physical custody. We will analyze the financial realities of asset division, investigating how the transition from equitable distribution systems to community property frameworks fundamentally altered the wealth accumulation strategies of American households. This is not just a look into history, it is a blueprint of the modern social contract. By the end of this series, you will possess a comprehensive, data-driven understanding of the structural forces that shape our choices, our finances, and our collective future. To understand the modern landscape of 2026, we must step back into the structural foundation of early America, where the legal journey of marital dissolution was fundamentally defined by a total absence of individual autonomy. In the late 18th and early 19th centuries, the typical divorce journey was shaped by an oppressive legal doctrine known as coverture. Under coverture, a married woman's legal identity was completely suspended and incorporated into that of her husband. She could not legally own property, open a separate bank account, sign a contract, or retain her own wages. If a marriage became abusive or completely dysfunctional, the structural obstacles preventing a separation were nearly insurmountable, transforming the domestic sphere into a legal cage for the vast majority of American women. Imagine if you were a woman named Abigail living in Boston in the year 1795. Your husband, Charles, squanders your entire inherited family wealth on highly speculative shipping ventures, becomes abusive, and eventually flees the state with another woman. In this era, Abigail cannot simply walk into a local county courthouse, file standard paperwork, and expect a judge to divide their assets. Because family courts did not exist, Abigail's only path to a complete legal dissolution is to hire an exceptionally expensive attorney to draft a personal petition addressed directly to the Massachusetts General Court, which was the state legislature. This process of legislative divorce was a bureaucratic and social nightmare. The state legislature, composed entirely of wealthy male politicians, would review Abigail's private life during their legislative session. They would debate her character, examine the evidence of her husband's misconduct, and vote on whether her specific marital failure warranted the passage of a private act of the legislature to dissolve the union. Historical trends indicate that these legislative divorces were granted with extreme scarcity. Across entire states, often fewer than a dozen were approved per year, reserved almost exclusively for the ultra-wealthy elite who possessed the political capital and financial liquidity to fund a legislative lobbying campaign. For the average citizen, this public shaming mechanism served as an absolute deterrent, keeping the visible rate of marital dissolution across the early United States close to zero. By the mid-19th century, a massive demographic shift forced a restructuring of this entire framework. As the American population expanded through immigration and industrialization, state legislatures became completely overwhelmed by hundreds of unhappy couples, flooding their legislative dockets with personal grievances. To clear this administrative bottleneck, states systematically transferred the authority to grant divorces from the legislative branch to the judicial branch. This transition gave birth to the fault-based judicial system, a rigid adversarial framework that would govern the American divorce journey for more than a century. Under this new judicial framework, a divorce could not be granted simply because two people no longer loved each other. The law required a clear winner and a clear loser. To secure a dissolution, the filing spouse had to present absolute, undeniable proof that the other spouse had committed a specific statutory crime against the marriage. The only legally recognized grounds were typically restricted to adultery, long-term physical desertion, or extreme physical cruelty that actively threatened the life of the spouse. If both parties were found to be unhappy, or if both parties had contributed to the breakdown of the relationship, a legal doctrine known as recrimination applied. Under recrimination, if a judge discovered that both the husband and the wife had committed marital offenses, the court would deny the divorce entirely, legally forcing two people who mutually despised each other to remain bound together in perpetuity. Consider a case study from 1855 New York involving a couple named Thomas and Martha. After 15 years of marriage, they have grown completely incompatible. There is no physical abuse, no abandonment, and no infidelity. They have simply grown apart and wish to separate amicably. Under New York law at the time, the only statutory ground for an absolute divorce was proven adultery. If Thomas and Martha attempt to cooperate, split their household goods, and tell the judge that they both desire a dissolution, the law labels their cooperation as collusion. The moment a judge suspects collusion, the case is instantly thrown out of court. To circumvent these draconian restrictions, affluent couples were forced to engage in elaborate, highly deceptive legal fabrications. Thomas would have to hire a private investigator, rent a hotel room, arrange for a paid actress to be seen in the room with him, and ensure that independent witnesses caught them in a carefully staged, scandalous scenario. This fabricated evidence would then be presented in court to satisfy the strict letter of the law. This structural hypocrisy turned the legal journey into an expensive, fraudulent game accessible only to the wealthy elite who could afford private eyes, actors, and cooperative attorneys, leaving ordinary citizens trapped. This stark legal divide created America's very first major demographic phenomenon of migratory divorce. When one state maintained exceptionally strict domestic laws, an adjacent state inevitably recognized a massive economic opportunity by loosening theirs. In the mid-19th century, the state of Indiana became the nation's premier divorce colony. Indiana statutory law allowed for dissolution based on a highly flexible omnibus clause, which granted local judges the power to dissolve a marriage for any emergency or cause they deemed reasonable. Furthermore, Indiana dropped its residency requirement to just 6 months, compared to the multiple years required by eastern states. Let us look at the historical trends through the journey of a wealthy New York merchant named William in 1858. Recognizing that he could never secure a legal separation in Manhattan without a catastrophic public scandal, William boarded a westbound train to Indianapolis. He rented a room at a local boarding house, established a nominal business presence, and waited out his 6 months. His wife, remaining back in New York, frequently received notice of the lawsuit only through an obscure legal advertisement placed in a local Indiana newspaper that she would never realistically see. Once the 6-month residency period concluded, William appeared before a compliant Indiana judge, secured his decree, and returned to New York a single man. The demographics of this early migratory journey were intensely skewed toward affluent men, who possessed the financial mobility to abandon their daily lives for half a year to exploit interstate legislative loopholes. For the working-class population of the 19th century, the financial reality of this journey was completely out of reach. The average laborer earned less than $1 a day, while court fees, travel expenses, and attorney retainers could easily exceed $100. Consequently, the typical working-class journey did not involve courts, lawyers, or migratory travel to Indiana. Instead, it involved the simple, brutal reality of informal desertion. Husbands would walk out the front door and disappear completely into the rapidly expanding western frontier, or the anonymous tenements of rapidly industrializing cities. This created a massive, undocumented demographic subpopulation across the United States. The rise of the de facto single mother household long before modern social safety nets existed. Because of coverture and the lack of legal dissolution, these abandoned women remained permanently tied to their missing husbands. If an abandoned wife managed to save money, buy property, or start a small shop, her runaway husband could legally return years later and claim every penny of her earnings and assets as his own property. The structural horror of this historical journey was further amplified by the legal framework governing child custody. Under English common law principles that dominated early American jurisprudence, children were viewed primarily as economic assets. In an agrarian economy, a child represented vital field labor. In an early industrial economy, a child's wages from a textile mill belonged directly to the head of the household. Therefore, if a marriage dissolved, the law almost universally awarded custody of the children to the father, regardless of his behavior. Mothers who contemplated fleeing abusive marriages faced an agonizing calculation. Securing their personal safety meant permanently surrendering their children to the very man they were fleeing. This structural weaponization of custody served as a massive demographic anchor, artificially suppressing the visible divorce rate by keeping millions of women trapped in highly volatile domestic environments. By the late 19th century, as the national divorce rate slowly crept upward from less than 1% to roughly 5% of all marriages, a massive wave of moral panic swept through the American political establishment. Religious organizations formed national leagues to combat the perceived destruction of the traditional family unit. This cultural backlash pressured states like Indiana to rapidly tighten their residency requirements and eliminate their lenient clauses, effectively shutting down the early Midwestern migratory pathways. As the 19th century closed, a profound systemic tension emerged. The forces of industrialization, urbanization, and the early women's suffrage movement were pulling the American population away from traditional agrarian dependency, yet the legal framework remained stubbornly anchored in Victorian concepts of fault, punishment, and marital indissolubility. The demand for domestic freedom did not disappear. It simply searched for a new legal path of least resistance. This search would eventually lead to a dramatic geographic relocation, shifting the epicenter of the American divorce journey from the Midwestern prairies to a barren desert oasis that would completely institutionalize, commercialize, and revolutionize the dissolution of marriage on a global scale. What happened when an entire state decided to turn the dissolution of marriage into its primary economic engine, attracting thousands of affluent Americans to rent cabins, ride horses, and wait out a 6-week clock just to buy their freedom? And how did this commercialized system lay out the exact blueprint for the modern multi-billion-dollar family law industry we see today? The migration toward the high desert of Nevada transformed the American divorce journey from a secretive, shameful legal ordeal into a highly organized, state-sanctioned commercial enterprise. Throughout the early 20th century, Nevada systematically identified a lucrative economic niche by exploiting the rigid, fault-based domestic policies of heavily populated eastern states. While New York and Pennsylvania maintained strict statutory grounds that forced couples into public humiliation or perjury, Nevada realized it could generate substantial state revenue by offering an efficient, standardized alternative. In 1927, the Nevada legislature passed a bill reducing the state residency requirement for legal dissolution to just 3 months. Recognizing the immediate economic influx this legislative change produced, the state went even further in 1931. In the middle of the Great Depression, while the rest of the United States faced severe economic devastation, Nevada dropped its residency requirement to an astonishing 6 weeks, while simultaneously legalizing casino gambling. This created a highly efficient, dual-industry economic engine that completely revolutionized how modern marital dissolution was processed and perceived. Imagine if you were an affluent woman named Helen living in Chicago in the year 1938. Helen is trapped in a deeply dysfunctional, emotionally abusive marriage with a prominent corporate executive. Under Illinois law at the time, securing a dissolution would require a highly publicized trial, explicit proof of cruelty or abandonment, and the total destruction of her family's social standing. Instead of enduring this public gauntlet, Helen utilizes her financial resources to embark on what contemporary society termed the Reno Cure. She purchases a ticket on a luxury transcontinental train and travels west across the country. Her destination is not a courthouse or a hidden law office, but a specialized high-end guest ranch located on the outskirts of Washoe County. This infrastructure gave rise to the historic demographic phenomenon of the divorce ranch. These ranches were highly sophisticated hospitality operations designed explicitly to cater to wealthy out-of-state individuals who needed to fulfill their 6-week residency requirement without violating local laws. Establishments like the Washoe Pines Ranch or the Flying Me Ranch offered upscale accommodations, horseback riding, guided wilderness excursions, and high-end dining. For 42 consecutive days, Helen lives a highly regimented double life. To the external world, she is a wealthy tourist enjoying the rustic charm of the American West. To the legal system, she is establishing a permanent, bona fide domicile within the jurisdiction of Nevada. The step-by-step mechanics of this journey required absolute compliance with strict administrative guidelines. Helen could not simply check into a hotel and disappear. She had to be seen daily by the ranch owner or local merchants, who could later testify under oath as independent witnesses to her physical presence in the state. If Helen crossed the nearby state line into California for a brief weekend excursion or a shopping trip, her 6-week clock would instantly reset to zero. This strict legal confinement created a unique, highly concentrated demographic subculture. For the first time in American history, hundreds of affluent women from diverse geographic regions were concentrated in a single location, sharing their personal stories of domestic unhappiness, asset distributions, and custody battles. This environment fostered an early, informal network of female solidarity that directly challenged the dominant cultural narrative that marital failure was an isolated, individual moral failing. Once the 42 days concluded, the final legal step was remarkably brief. Helen's attorney would escort her to the Washoe County Courthouse in downtown Reno. Unlike the adversarial courtrooms of Chicago or New York, the Nevada proceedings were highly streamlined and transactional. The independent witness would take the stand, swear under oath that Helen had resided continuously in Nevada for 6 weeks, and Helen would state that her husband had committed mental cruelty, a highly flexible statutory category allowed under Nevada law. Within less than 15 minutes, a cooperative judge would sign the final decree. Upon exiting the courthouse, Helen would participate in a famous local ritual, walking to the nearby Virginia Street Bridge and throwing her wedding ring directly into the Truckee River, symbolizing her immediate transformation into an independent, single consumer. However, historical trends show that the Reno demographic pipeline was profoundly stratified by socioeconomic class. The total cost of this journey was immensely high. Between train fare, 6 weeks of lodging at a specialized guest ranch, local attorney retainers, and court filing fees, the minimum expenditure could easily range from $1,000 to $3,000 in 1930s currency. Adjusted for inflation, this represents tens of thousands of dollars, making the Reno journey an exclusive luxury option available only to the upper middle class and the ultra-wealthy elite. Working-class women and men across the United States remained entirely excluded from this system, left with no alternative but to remain in unstable marriages or resort to informal desertion, which offered no legal protections or structural stability for their children. This commercialized system quickly triggered a monumental constitutional crisis that reached the highest levels of the United States legal system. Conservative jurisdictions like North Carolina actively resisted the validity of these out-of-state decrees. This resistance led to a pair of landmark United States Supreme Court cases known as Williams v. North Carolina, decided in 1942 and 1945. The case emerged when a man named Oral Williams and a woman named Lily Hendricks left their respective spouses in North Carolina, traveled to a Nevada auto court, stayed for the required 6 weeks, secured their dissolutions, married each other, and returned home to North Carolina. The state of North Carolina refused to recognize the Nevada decrees and prosecuted the couple for bigamous cohabitation, sentencing them to prison. The Supreme Court was forced to interpret the full faith and credit clause found in Article 4, Section 1 of the United States Constitution, which mandates that states must respect the public acts, records, and judicial proceedings of every other state. In its final rulings, the Supreme Court established a complex legal framework. While states generally had to extend full faith and credit to out-of-state decrees, a state could independently review whether a person had established a genuine, permanent domicile in the granting state. If a court determined that the 6-week stay was merely a temporary sham intended solely to bypass local laws, the home state retained the legal authority to declare the out-of-state dissolution completely void. This ruling cast a long shadow of legal uncertainty over the Reno pipeline, demonstrating how regional political battles directly impacted the stability of American households. Following the conclusion of World War II, the demographic landscape of the United States experienced a massive realignment that placed unprecedented structural pressure on the traditional institution of marriage. The post-war era saw the rapid expansion of suburban developments, a historic surge in birth rates known as the baby boom, and an intense cultural push to return women from wartime factory employment back to exclusive domestic roles within the nuclear family. Yet, beneath the surface of the idealized 1950s suburban lifestyle, historical data reveals that the underlying tension within American households was accelerating toward an explosive tipping point. What happened when millions of post-war families found themselves trapped in a rigid social model that no longer aligned with the economic and psychological realities of a rapidly modernizing nation? How did the sudden, massive entry of women into higher education and the clerical workforce during the 1960s create an unsustainable conflict with a legal system that still demanded proof of a crime just to dissolve a partnership? And what occurred when a future United States president signed a single piece of legislation that permanently dismantled the fault-based system, triggering the single largest spike in marital dissolution in global history? That future president was Ronald Reagan, who, as governor of California, signed the Family Law Act of 1969. On January 1, 1970, this monumental law took effect, permanently rewriting the rules of American domestic life and launching a legal revolution that would sweep across all 50 states. Reagan later confided to biographers that signing this bill was one of the greatest political regrets of his career, but by then, the demographic wheels were already set in motion. The statute completely abolished the century-old concept of fault in the state of California. No longer did a spouse have to prove adultery, extreme cruelty, or willful desertion in an adversarial trial. Instead, a marriage could be dissolved based on the simple legal standard of irreconcilable differences, which had caused the irremediable breakdown of the marriage. This legal shift effectively stripped the courts of their traditional role as moral arbiters and turned the dissolution process into an administrative procedure. Let us trace the rapid cascading effect of this legislation across the United States map. What started in California in 1970 spread like a legal wildfire, because the underlying social and economic pressures had reached a boiling point. By the mid-1970s, the vast majority of American states had rushed to adopt some version of no-fault legislation to modernize their aging dockets. States like New York resisted the trend for decades, maintaining strict fault rules until 2010, but the national momentum throughout the late 20th century was entirely unstoppable. The legal system was simply scrambling to catch up to a massive demographic shift that had been building quietly beneath the surface of post-war society for more than 20 years. Imagine if you were a woman named Linda living in Detroit, Michigan, in the year 1974. Under the old fault-based system just a few years prior, if Linda wanted to leave an unhappy marriage, she would have faced a nearly impossible journey. She would have had to hire an expensive attorney, gather painful or fabricated evidence of her husband Robert's misconduct, and endure a highly publicized trial where her own moral character would be aggressively cross-examined. If Robert refused to grant a divorce, Linda was effectively trapped. But in 1974, following Michigan's adoption of no-fault laws, Linda's journey looks radically different. She can unilaterally file a petition for dissolution at a local clerk's office. Robert cannot stop the process. He cannot force her to stay by withholding his consent. The law now recognizes that if just one partner declares the marriage is over, the partnership is legally dead. This structural shift introduced the concept of unilateral divorce, which completely altered the balance of power within American households. In previous generations, the non-fault spouse held immense leverage in negotiations. If a husband wanted a divorce to start a new life, the wife could demand massive financial concessions, ownership of the family home, or substantial ongoing alimony payments in exchange for her willingness to cooperate in a fault-based courtroom. Under the no-fault framework, this leverage vanished overnight. The filing spouse no longer needed to buy the other person's consent. This structural realignment led to a complex web of potential outcomes for asset distribution and long-term financial security, particularly for women who had spent decades working exclusively as homemakers without establishing independent professional careers. The demographic data from this era paints a staggering picture of systemic change. In 1960, the United States divorce rate stood at roughly 2.2 per 1,000 people. By 1970, as no-fault laws began to take hold, that number climbed to 3.5. By 1980, the rate peaked at an all-time historical high of 5.3 per 1,000 people. This represents a literal doubling of the rate of marital dissolution in less than a single generation. Sociologists and economists analyzing these historical trends quickly realized that the law itself did not create the underlying desire for separation. Rather, it acted as a major structural catalyst, releasing decades of pent-up demand from individuals who were previously trapped by financial dependency or insurmountable legal roadblocks. To fully comprehend this demographic explosion, we must examine the concurrent revolution occurring in the American labor market. During the 1970s, women were entering the workforce in unprecedented numbers. This was not just a cultural choice. It was an economic necessity driven by the intense stagflation of the 1970s, where wage stagnation and high inflation meant that a single working class or middle class income could no longer comfortably support a suburban household. As women secured employment in rapidly expanding clerical, administrative, and professional sectors, the underlying economic calculation of marriage shifted fundamentally. Consider a historical case study analyzing a typical dual-income household in Ohio in 1976. For the first time, a wife had her own independent stream of income, her own Social Security contributions, and direct access to her own credit, thanks to the Equal Credit Opportunity Act of 1974, which made it illegal for creditors to discriminate against applicants on the basis of sex or marital status. Prior to this legislative milestone, a woman could not even obtain a credit card or a mortgage without a male co-signer. With economic independence achieved, the financial cost of leaving a dysfunctional marriage dropped precipitously. Marriage was no longer a strict survival mechanism for women. It became a voluntary association based on mutual compatibility. When that compatibility failed, the economic barriers to exit were finally low enough to allow for a swift transition out of the relationship. This massive influx of cases completely overwhelmed the American judicial infrastructure. Family courts, which had previously dealt with a manageable trickle of fault-based cases, were suddenly inundated with hundreds of thousands of filings annually. Judges who were trained in property law or corporate litigation found themselves forced to act as social workers, financial analysts, and child psychologists. The sheer volume of cases forced a rapid standardization of the legal process. Courts began utilizing formulaic charts, standardized asset spreadsheets, and rigid schedules to determine child support and asset division, stripping away individual nuance in favor of rapid administrative efficiency. This standardization created major financial challenges within the typical divorce journey. Under the old fault-based system, alimony or spousal support was often awarded as a permanent punitive measure against the guilty party. A husband found guilty of blatant misconduct would be legally compelled to maintain his ex-wife's standard of living for the rest of her life. In the new no-fault paradigm, the legal philosophy shifted from punishment to rehabilitation. Courts began to view alimony not as a permanent right, but as a temporary, transitional bridge designed to allow a dependent spouse to acquire the education or job training necessary to achieve self-sufficiency in the modern workforce. This shift in family law produced severe, unintended financial consequences. Historical trends from the late 1970s and early 1980s show that the immediate post-divorce standard of living for women and children frequently dropped significantly, while the standard of living for men often rose. Because women still faced a substantial gender wage gap in the broader economy and were predominantly tasked with primary child-rearing responsibilities, the loss of shared household economies of scale and the reduction of long-term alimony awards left millions of single-mother households in precarious financial positions. This systemic disparity triggered a massive national debate over how the law should value non-monetary contributions to a marriage, such as homemaking, childcare, and supporting a spouse through professional school. As the 1980s dawned, the legal system found itself facing a secondary crisis that flowed directly from the no-fault revolution. While the mechanics of dividing bank accounts and real estate could be reduced to mathematical formulas, the question of how to handle the human capital of the marriage, the children, became a fierce ideological battleground. The historical consensus that had quietly governed American custody decisions for half a century was about to be completely dismantled by a rising tide of fathers demanding equal parental rights and mothers fighting to retain their traditional roles. How did the sudden explosion of marital dissolutions in the late 20th century reshape the psychological and legal definition of the American family? What happened when states began to realize that the financial formulas used to calculate child support were driving millions of non-custodial parents into underground economies, creating a multi-billion-dollar enforcement apparatus managed by the federal government? And how did a new wave of academic research into the long-term impacts on the children of the baby boom generation completely alter how judges viewed the concept of the best interests of the child, setting the stage for a dramatic shift toward joint custody arrangements that would redefine parenting in the 21st century? To understand this dramatic shift, we must look at the collapse of a legal doctrine that had quietly dominated American family law for over a century: the tender years doctrine. Historically, the legal system operated on a powerful maternal presumption, dictating that during a child's tender years, which were typically defined as infancy through early childhood, the mother was naturally and uniquely equipped to provide the necessary emotional and physical care. This meant that in the rare instances of marital dissolution prior to the 1970s, custody was almost automatically awarded to the mother, while the father was relegated to the role of an external financial provider. However, as the no-fault revolution swept across the United States, fathers' rights groups, civil rights attorneys, and sociologists began to launch systematic legal challenges against this doctrine, arguing that an automatic gender-based presumption violated the Equal Protection Clause of the 14th Amendment. This legal warfare forced a massive structural transition toward a completely new legal standard: the best interests of the child. Under this modernized framework, the law stripped away automatic gender preferences and mandated that judges evaluate each parent on an individualized, gender-neutral basis. Imagine a father named Michael living in Denver, Colorado, in the year 1984. Michael is a dedicated corporate accountant who has spent years actively participating in his children's daily lives, from preparing meals to helping with schoolwork. Under the old tender years framework, Michael would have faced a nearly impossible task in securing custody, regardless of his parenting capabilities. But under the newly implemented best interests framework, the court must meticulously analyze a multi-factor statutory checklist. This checklist includes the wishes of the child's parents, the wishes of the child, the interaction and interrelationship of the child with their parents and siblings, the child's adjustment to their home, school, and community, and the mental and physical health of all individuals involved. This structural shift completely transformed the typical custody journey into an incredibly complex, highly adversarial, and expensive psychological evaluation process. To prove compliance with the best interest standard, Michael and his wife Susan can no longer rely on simple courtroom testimony. The legal process now requires the deployment of a massive auxiliary industry of forensic psychologists, court-appointed social workers, and guardian ad litem attorneys whose sole job is to represent the independent interests of the children. These professionals conduct extensive home studies, perform standardized personality assessments like the Minnesota Multiphasic Personality Inventory, and observe parental interactions in controlled environments. This level of clinical scrutiny turned the custody journey into a protracted administrative gauntlet, significantly increasing the total financial cost of dissolution for middle-class American families. The demographic consequence of this transition was the historic rise of joint custody arrangements. Throughout the late 1980s and 1990s, states systematically modified their statutes to declare that joint legal custody, where both parents retain equal decision-making authority regarding the child's education, healthcare, and religious upbringing, was the preferred and optimal outcome for children. Shortly thereafter, joint physical custody, where the child divides their actual living time more equitably between two separate households, began to gain widespread traction. This fundamentally altered the spatial and logistical layout of the typical American family journey. Children of divorce were no longer visiting their fathers for a superficial Sunday afternoon. They were actively navigating a dual household existence, balancing two separate sets of bedrooms, school bus routes, and domestic rules. This structural duplication of the household unit created immense hidden economic strains, forcing both parents to maintain larger living spaces and duplicate basic necessities like clothing, technology, and toys. While the physical and psychological dimensions of custody were undergoing this massive re-engineering, financial dimensions of child rearing after separation were triggering a full-scale national crisis. Throughout the 1970s and early 1980s, the calculation of child support was notoriously arbitrary. A local judge would sit on the bench, review the basic financial declarations of the parties, and declare a monthly child support figure based on a vague, highly subjective assessment of what seemed reasonable. There were no standardized tables, no automated software systems, and absolutely no uniform guidelines. Historical trends from this era revealed a catastrophic systemic breakdown. Within 1 to 2 years of a divorce decree, a staggering percentage of non-custodial parents simply stopped paying their child support entirely or fell profoundly into arrears. Because the state-level enforcement mechanisms of the era were weak and fragmented, hundreds of thousands of single-mother households were left completely destitute, forcing them to rely heavily on state welfare programs like aid to families with dependent children. The federal government quickly realized that the non-payment of child support was not just a private domestic dispute. It was a massive drain on the federal treasury, shifting the financial obligation of raising children from individual parents to the American taxpayer. Congress intervened with immense force, utilizing its spending power to permanently federalize the mechanics of child support enforcement. The transformation culminated in the Child Support Enforcement Amendments of 1984 and the Comprehensive Family Support Act of 1988, which mandated that every single U.S. state must establish rigid, mathematical formulas for calculating child support awards as a strict condition for receiving federal welfare funding. To see exactly how this mathematical system operates, let us break down the mechanics of the income shares model, which became the dominant formula adopted by the vast majority of state jurisdictions. The underlying economic philosophy of this model is that a child should receive the exact same proportion of parental income that they would have received if the parents had remained married in a single household. The calculation follows a strict step-by-step bureaucratic process. First, the court determines the gross monthly income of both parents and applies specific deductions for taxes, prior obligations, and health insurance to arrive at a combined net income. Second, the court consults a state-mandated economic grid, which cross-references the combined net income with the total number of children to find the basic child support obligation. For example, if a combined parental net income is $10,000 a month for 2 children, the state table might dictate a basic monthly obligation of $2,000. Third, this basic obligation is divided between the parents proportionally based on their percentage share of the total income. If the father earns $7,000 a month, he is responsible for 70% of the obligation or $1,400, while the mother, earning $3,000, is responsible for 30%. Fourth, the formula adds extraordinary expenses to the base obligation, such as the actual cost of work-related childcare and health insurance premiums, dividing those costs by the same percentage split. Finally, the system applies a parenting time adjustment or an overnight cross-credit. If the non-custodial parent exercises more than a specific threshold of overnights per year, typically around 110 nights, the mathematical formula automatically reduces their monthly cash obligation to account for the direct expenses they incur while feeding and housing the children during their physical custody periods. To enforce these rigid mathematical calculations, the federal government mandated the creation of a massive, computerized domestic surveillance and enforcement infrastructure known as the Title 4D program. This completely stripped away the choice of whether or not to pay child support. The law introduced mandatory immediate wage withholding, which meant that child support orders were served directly onto the employers of non-custodial parents. The payment was automatically garnished from their paychecks before the net wages ever hit their bank accounts, flowing directly into a centralized state disbursement unit. State agencies were equipped with sweeping administrative powers that bypassed traditional judicial due process. Through the creation of the National Directory of New Hires, the federal government tracked every W-4 form filed across state lines, allowing state enforcement agencies to instantly locate and garnish the wages of parents who cross state borders to evade their financial obligations. The potential outcomes for failing to comply with these automated systems became incredibly severe. If a non-custodial parent accumulates arrears above a specific statutory threshold, the automated state computers trigger a series of draconian enforcement protocols. The system automatically intercepts federal and state tax refunds, places liens directly on bank accounts and insurance settlements, reports the delinquency to major credit bureaus to destroy the individual's credit rating, passport applications are automatically denied by the Department of State, and local jurisdictions automatically suspend driver's licenses, hunting licenses, and professional credentials. Consider a case study analyzing the real-world impact of this automated rigidity on a working-class industrial laborer named David living in Pennsylvania in the early 1990s. David is laid off from his manufacturing job due to a major economic recession and widespread plant closures. His child support obligation, which was legally calculated during his peak earning years, remains completely fixed at his previous income level. Under federal law, child support arrears accrue automatically as a non-dischargeable judgment by operation of law, and the Bradley Amendment explicitly prohibits judges from retroactively modifying or reducing child support debt that has already accumulated, regardless of the reason for non-payment. Because David lacks the financial literacy and the capital to immediately hire a private family law attorney to file a formal motion for a downward modification, his debt skyrockets. The automated enforcement system kicks in. His driver's license is suspended for non-payment. Now, David cannot legally drive to job interviews or commute to low-wage temporary employment without risking immediate arrest for driving under suspension. His specialized commercial trade certification is frozen by the state licensing board, effectively barring him from working in the only industry where he possesses marketable skills. This creates a destructive structural trap where the bureaucratic mechanisms designed to extract financial support actively destroy the parent's actual capacity to generate income, driving millions of working-class individuals into the underground cash economy or chronic unemployment. This stark systemic divide created a profound socio-economic stratification within the typical divorce journey. While affluent individuals possess the financial mobility and legal counsel to rapidly navigate modifications, manage tracking systems, and utilize specialized accounting to shield their assets, working-class families were frequently crushed by the unyielding weight of the automated state apparatus. This massive intersection of technology, federal surveillance, and mathematical modeling turned the post-divorce family into a permanent, lifelong bureaucratic partnership managed directly by the state. But as the United States transitioned into the late 1990s and early 2000s, an entirely new structural disruption emerged that would completely destabilize these carefully engineered financial models. What happened when the primary source of household wealth completely shifted away from traditional tangible assets like real estate, vehicles, and standard savings accounts into highly abstract, volatile, and complex financial instruments? How did the sudden explosion of 401ks, unvested stock options, restricted stock units, and digital intellectual property create a massive new battlefield for high-conflict litigation? And how did a new generation of dual-income corporate professionals force family law courts to completely redefine what actually constitutes marital property in an economy where wealth is increasingly invisible, setting off a frantic rush for advanced forensic asset valuation that would permanently transform the economic warfare of marital dissolution? The financialization of the American economy in the final decades of the 20th century fundamentally reconstructed the battlefield of marital dissolution, shifting the primary focus from tangible physical property to complex, invisible financial instruments. In the agrarian and early industrial eras of the United States, the division of assets was a relatively straightforward administrative task. Courts evaluated the family home, the family farm, physical vehicles, livestock, and standard savings accounts. However, as the American workforce transitioned away from traditional manufacturing and toward a knowledge-based, corporate-dominated landscape, the nature of household wealth underwent a radical transformation. By the late 1990s and early 2000s, the typical middle-class and upper-class household balance sheet was heavily weighted with abstract assets, including defined contribution plans, stock options, restricted stock units, and corporate deferred compensation structures. This evolution forced the family law framework to invent entirely new legal and financial mechanisms to track, value, and distribute these invisible assets, turning the typical divorce journey into an intensive exercise in forensic accounting. To navigate this modern financial maze, the legal system relies on a foundational step-by-step process designed to segregate marital property from separate property. While the rules vary between community property states, which mandate an automatic 50-50 split of all assets acquired during the marriage, and equitable distribution states, which divide property based on a judicial assessment of fairness, the initial classification process is identical across all jurisdictions. Separate property generally encompasses any asset owned by an individual prior to the marriage, as well as personal inheritances or gifts received during the union. Marital property, conversely, includes any asset, income, or debt accumulated by either spouse during the marriage, regardless of whose name is officially listed on the title or account. The primary complication arises through a process known as transmutation, where separate property becomes inadvertently mixed with marital property over time. Imagine a scenario where an individual enters a marriage with a personal investment account containing $100,000 of separate capital. If, over the course of a 10-year marriage, that individual regularly deposits marital earnings into that account, or uses funds from that account to pay down the mortgage on a jointly owned family home, the separate nature of the original capital becomes legally contaminated. The law views this commingling as evidence of an intent to transform the separate asset into a joint marital asset. To unravel this entanglement, family law courts require a meticulous, retrospective tracking process, where forensic accountants trace every single financial transaction back to its point of origin to determine the precise percentages of separate and marital equity remaining within the account. This level of financial scrutiny became legally standardized following the passage of the Employee Retirement Income Security Act of 1974, which revolutionized how retirement assets were protected, and the subsequent Retirement Equity Act of 1984, which introduced the mechanism known as the Qualified Domestic Relations Order, or QDRO. Prior to these legislative milestones, dividing a corporate pension or a corporate savings plan was an administrative nightmare that frequently left dependent spouses completely excluded from the future retirement security generated during the marriage. A traditional retirement account cannot simply be liquidated or split by a standard divorce decree. Doing so would instantly trigger massive early withdrawal penalties and catastrophic immediate income tax liabilities under the Internal Revenue Code. The execution of a QDRO solves this structural barrier through a highly technical, multi-step bureaucratic procedure. First, the divorce decree must explicitly state how the retirement asset is to be divided, often using a standard percentage split or a specific dollar amount calculated as of a precise valuation date. Second, a specialized family law attorney drafts a separate QDRO document, which must be approved and signed by the presiding judge. Third, this court-approved order is transmitted directly to the corporate plan administrator of the retirement fund. The plan administrator reviews the document with extreme precision to ensure it complies exactly with the statutory requirements of federal law and the specific internal rules of the corporate plan. Once approved, the plan administrator segregates the specified portion of the funds into an independent account for the alternate payee, typically the non-employee spouse. This process allows the non-employee spouse to roll their share of the marital asset directly into an individual retirement account without experiencing immediate taxation or financial penalties, establishing a vital baseline of long-term financial security. However, historical trends from the peak of the dot-com boom and the subsequent technology expansions of the early 21st century introduced an even greater level of volatility into the divorce journey. The widespread utilization of equity-based executive compensation packages. Corporate employers increasingly relied on unvested stock options and restricted stock units, known as RSUs, to attract talent and incentivize long-term performance. Because these financial assets are fundamentally tied to future employment milestones and market performance, they do not possess a simple, easily accessible liquidation value at the moment a divorce petition is filed. This temporal lag created an intense legal debate over how to calculate the marital share of an asset that has been granted during the marriage, but will not actually vest or deliver tangible financial value until years after the marriage has been legally dissolved. Consider a case study analyzing the real-world impact of these complex financial structures during a high-stakes corporate separation in Seattle during the early 2000s. Imagine a senior technology executive named Christopher and his spouse, Amanda, who are dissolving their marriage after 12 years. Christopher holds thousands of unvested corporate stock options that were granted halfway through the marriage, but are scheduled to vest in sequential tranches over the next 4 years. To resolve this dispute, the family law court cannot simply guess the future value of the stock. Instead, the court applies a specialized mathematical formula known as the time rule, or the Covery formula. The step-by-step application of the time rule requires the court to construct a strict mathematical fraction for each individual tranche of options. The numerator of the fraction represents the total number of months from the date the stock option was originally granted to the physical date of the marital separation. The denominator represents the total number of months from the original grant date to the future date of vesting. The resulting percentage represents the definitive marital portion of that specific asset, which is then divided equitably between the parties. The remaining percentage is legally classified as Christopher's separate property, earned through his post-separation labor. Once the options actually vest in the future, Christopher is legally compelled to exercise the marital portion and distribute the net proceeds to Amanda, creating a prolonged, post-divorce financial entanglement that requires absolute precision and ongoing accountability. The incredible complexity of these abstract assets gave rise to the modern necessity of advanced forensic asset valuation, particularly when dealing with small business owners or private corporate practices. When an individual owns a business, the value of the enterprise is not merely composed of physical assets like inventory, machinery, or office furniture. A massive portion of the business's true economic value resides in its intangible assets, specifically enterprise goodwill and personal goodwill. Enterprise goodwill represents the established reputation, operational systems, and customer loyalty that exist independently of the business owner. The law views this as a divisible marital asset. Personal goodwill, conversely, represents the individual skill, reputation, and personal relationships of the specific business owner, which cannot be easily transferred to a third party. The law generally classifies this as separate property. To separate these two abstract concepts, forensic accountants utilize sophisticated valuation methodologies, such as the capitalization of excess earnings method. This process involves determining the historical net earnings of the business, subtracting a reasonable salary for the owner based on rigorous market data, and applying a capitalization rate to the remaining excess earnings to isolate the exact value of the enterprise goodwill. This mathematical modeling is highly contentious, often resulting in a battle of expert witnesses in the courtroom, where a slight modification of the chosen capitalization rate can alter the final valuation of the marital estate by hundreds of thousands of dollars. These systemic financial complexities were further exposed to extreme stress during major national macroeconomic shocks, such as the global financial crisis of 2008. Historical trends reveal that during periods of extreme market volatility, the choice of the legal valuation date becomes the single most critical variable in the entire property distribution process. If a family law court establishes the valuation date of a marital stock portfolio or a luxury real estate holding at the initial filing date in the spring, but the global economy experiences a systemic crash before the final trial concludes in the autumn, the asset allocation model becomes completely disconnected from reality. A spouse ordered to pay a fixed cash equalization payment based on peak spring values could be completely bankrupt by winter, demonstrating how macroeconomics directly dictates the survival or destruction of post-divorce wealth. As the United States moved past these 20th century financial revolutions and entered the highly digitized landscape of the modern era, a profound behavioral shift began to occur across the American demographic map. The sheer financial trauma, extreme litigation costs, and administrative burdens observed during the late 20th century divorce boom left a permanent psychological scar on subsequent generations. What happened when the children of the baby boom generation, having witnessed the systematic liquidation of their parents' wealth and the chaotic partitioning of their childhood homes, reached adulthood and decided to completely rewrite the rules of engagement? How did the sudden rise of delayed marriage timelines, cohabitation trends, and the institutionalization of the prenuptial agreement among everyday middle-class couples fundamentally alter the statistical trajectory of relationships, setting the stage for a dramatic, unprecedented collapse in the national divorce rate that continues to baffle traditional social observers? The explanation for this statistical decline lies within a profound generational shift in how relationships are formed, evaluated, and legally codified. For decades, popular culture repeated the statistic that 50% of all marriages in the United States end in dissolution. While that figure was relatively accurate during the historic peak of the no-fault revolution in the late 1970s and early 1980s, it completely fails to capture the demographic reality of the current landscape in 2026. The national divorce rate has been on a downward trajectory for more than 25 years. This decline is not driven by an increase in marital stability among all citizens, but rather by a radical change in the demographic composition of the marrying population itself. Marriage is no longer a default rite of passage entered into by nearly all young adults. Instead, it has increasingly become a deliberate choice made by older, highly educated, and financially secure individuals. To understand the mechanics of this decline, sociologists isolate a phenomenon known as the selection effect. In the mid-20th century, the cultural timeline of the typical American life cycle was highly standardized. Individuals regularly completed high school, entered the workforce or married immediately, and established a nuclear household by their early 20s. In 1970, the median age for a first marriage stood at just 20 years for women and 23 years for men. Historical trends show that marrying at a young age is one of the single most powerful statistical predictors of future marital dissolution, as individuals are forced to navigate major economic stresses and personal identity developments while simultaneously managing a legal partnership. Imagine if you look at a modern professional named Jessica living in Austin, Texas, in the year 2026. Jessica's life path contrasts sharply with that of her mother, Linda, who married in 1974 at the age of 21. Jessica is 31 years old and has spent her 20s completing a graduate degree, establishing a stable career in software product management, and building an independent financial foundation. She has lived in her own apartments, managed her own credit, and accumulated her own savings before ever considering a legal marriage. By the time Jessica enters into a marital contract in 2026, the median age for first marriage in the United States has risen to an all-time historical high of nearly 29 years for women and over 30 years for men. This delay means that modern couples are entering into legal unions with a level of emotional maturity, career stability, and financial literacy that was structurally absent among younger cohorts in previous generations. This delayed entry into marriage is structurally enabled by the cohabitation revolution. In the 1960s and 1970s, living together outside of wedlock was socially stigmatized and, in some jurisdictions, actively illegal under archaic lewd and lascivious cohabitation statutes. Today, cohabitation has become the standard preparatory phase for the vast majority of American relationships. Historical data indicates that more than 70% of modern couples live together before walking down the aisle. In the past, early social science research suggested that cohabitation actually increased the probability of future divorce, a pattern termed the cohabitation effect. However, modern demographic analysis reveals a much more nuanced reality. The widespread adoption of cohabitation acts as a highly efficient filter for unstable relationships. In 2026, couples utilize cohabitation as a real-world trial run to test emotional compatibility, domestic labor distribution, and financial alignment. If the relationship fails to withstand the daily frictions of shared domestic life, the couple separates without ever entering the judicial system. The dissolution of a cohabiting relationship requires no court filings, no expensive family law attorneys, and no public asset division. Consequently, these relationship failures occur entirely outside the demographic data tracks of the family court system. The individuals who successfully navigate years of cohabitation and eventually transition into marriage represent a highly vetted, self-selected group whose unions are statistically far more resilient from day one. This brings us to a highly significant socioeconomic divergence, known as the marital divide. While the overall national divorce rate is declining, this trend is intensely stratified by educational attainment and income level. Marriage has increasingly become a luxury good. Individuals with a bachelor degree or higher are marrying at steady rates, and their marriages are exhibiting unprecedented levels of stability, with historical trends suggesting that less than 30% of college-educated couples dissolve their unions. Conversely, individuals with a high school education or less are marrying at significantly lower rates and face a much higher probability of relationship dissolution. For working-class Americans, the barriers to establishing a stable marriage have multiplied. Wage stagnation in traditional industrial sectors, the decline of stable manufacturing employment, and the rising cost of housing have made the financial baseline required for marriage feel completely out of reach. In this demographic segment, couples frequently opt for long-term cohabitation or single parenthood, not out of a lack of commitment to the institution of marriage, but because they lack the economic security that serves as the foundation for marital longevity. When these working-class cohabiting unions dissolve due to economic stress, the social and financial impact on the family unit is profound, yet it remains completely invisible in traditional divorce rate statistics. For the affluent professionals who do choose to marry in 2026, the legal journey has been completely transformed by the institutionalization of the prenuptial agreement. Historically, prenuptial agreements were viewed as an exclusive luxury tool reserved for billionaires, Hollywood celebrities, or old-money dynastic families seeking to protect inherited estates from external claims. In the modern era, prenuptial agreements have undergone a massive democratization, becoming a standard risk management tool for everyday middle-class professionals, particularly millennials and Gen Z. The step-by-step motivation behind this trend is rooted in the fact that because people are marrying much later in life, they are entering the union not as blank slates, but as independent economic entities who have already accumulated significant assets and liabilities. A typical 32-year-old professional in 2026 might enter a marriage already owning a condominium, holding a well-funded 401k retirement account, possessing unvested stock equity from a startup employer, or carrying a massive burden of undergraduate and graduate student loan debt. They view a prenuptial agreement not as a cynical anticipation of marital failure, but as a rational business contract designed to define separate property, establish clear boundaries for premarital liabilities, and outline potential outcomes for asset division and spousal support in advance. To be legally enforceable in a modern family court, a prenuptial agreement must strictly satisfy a series of rigorous statutory guidelines. Under the Uniform Premarital Agreement Act, which has been adopted by the vast majority of United States jurisdictions, the contract must be executed voluntarily by both parties. Furthermore, both individuals must provide a full, honest, and meticulous financial disclosure of all assets, debts, and income streams. If one party attempts to hide a bank account or undervalue a business asset during the negotiation process, a judge can completely invalidate the entire agreement years later. Crucially, the law requires that both the husband and the wife have independent legal counsel. A single attorney cannot represent both parties to ensure that the terms are fair, and that neither individual is subjected to duress or unconscionable pressure. This normalization of legal forecasting has fundamentally altered the initial phase of the modern marriage journey, forcing couples to engage in radical financial transparency before they ever say their vows. But as we look at how technology, delayed timelines, and legal planning have stabilized marriages for the younger generation, a massive countertrend is occurring simultaneously at the exact opposite end of the demographic spectrum. What happens when the generation that originally drove the divorce boom of the 1970s and 1980s reaches their golden years, looks at their empty nests, and decides to dismantle their long-term marriages in unprecedented numbers? How has the sudden, explosive rise of gray divorce completely disrupted the retirement security infrastructure of the United States? And what occurs when a 65-year-old couple enters a modern courtroom to divide an entire lifetime of accumulated wealth, only to discover that the introduction of a new digital footprint, smart devices, and algorithmic financial tracking has completely rewritten how hidden assets are exposed and litigated in the 21st century? This digital revolution has completely upended the landscape of gray divorce, a demographic phenomenon that is currently transforming the socio-economic reality of older Americans in 2026. While the broader national divorce rate has experienced a steady decline among younger generations who choose to delay marriage, the rate of marital dissolution among adults aged 50 and older has dramatically doubled since the late 20th century. For those aged 65 and older, historical trends indicate that the rate has nearly tripled. This massive demographic shift is driven by a unique confluence of extended life expectancies, the historic financial independence of baby boomer women, and a profound cultural evolution regarding personal fulfillment in the later stages of life. When a couple separates after 30, 40, or 50 years of marriage, they are not navigating the child custody battles or early career stresses that define younger liquidations. Instead, they are entering an absolute economic minefield where a lifetime of accumulated wealth must be systematically divided at a time when the biological clock severely limits their capacity to recover financially. To understand the immense structural stakes of a modern gray divorce, we must analyze the concept of household economies of scale. When two individuals share a single primary residence, pool their utility expenses, share insurance policies, and purchase groceries in bulk, they achieve a high level of financial efficiency. The moment that household splits into two separate geographic entities, the cost of maintaining the exact same standard of living instantly skyrockets by approximately 40 to 50%. For seniors living on fixed incomes, retirement portfolios, or Social Security benefits, this sudden duplication of structural living costs can be economically devastating. The historical trends tracking post-divorce poverty rates among seniors reveal a stark gender disparity. Women undergoing a gray divorce experience an average drop in their standard of living of 45%, while men experience a decline of approximately 21%. Imagine a real-world case study in the year 2026 involving a couple named Richard and Eleanor, both aged 67, who are ending their 38-year marriage in Columbus, Ohio. They own a fully paid-off suburban home valued at $500,000, a combined 401k retirement portfolio worth $1.2 million, and various liquid savings accounts. In a traditional property division framework, these assets would likely be split equitably or equally. However, the practical liquidation of these assets triggers a complex series of potential outcomes. If they sell the marital home to divide the cash equity, both Richard and Eleanor are suddenly thrust into a highly volatile 2026 real estate market, forced to buy or rent independent properties at peak interest rates and elevated historical costs. Furthermore, the splitting of the $1.2 million retirement account via a qualified domestic relations order means that instead of a unified pool generating compound interest for a single household, each individual must now survive on the investment yields of $600,000 while bearing independent inflation risks and escalating healthcare costs. This financial calculation is further complicated by the intricate administrative rules governing Social Security auxiliary benefits, a critical legal lifeline that many older Americans completely misunderstand. Under federal statutory guidelines, A divorced individual can legally claim a monthly Social Security benefit based on the prior earnings record of their ex-spouse, rather than their own independent work history, provided that the marriage lasted for a continuous duration of at least 10 years. Crucially, the filing spouse must be at least 62 years of age and must remain unmarried. If Eleanor spent decades working primarily as a homemaker or working part-time jobs without accumulating substantial individual Social Security credits, she can claim up to 50% of Richard's higher primary insurance amount. This administrative mechanism does not reduce Richard's personal monthly check. The federal government funds the auxiliary benefit independently out of the Social Security Trust. However, if Eleanor were to remarry before the age of 60, this structural safety net would instantly vanish, demonstrating how historical legislative policies directly dictate the personal and romantic choices of older demographic cohorts. While these traditional macroeconomic structures remain highly complex, the modern courtroom of 2026 has introduced a terrifying new layer of technological warfare into the property division process: the immutable digital footprint. In previous decades, an individual attempting to shield assets from their spouse during a dissolution would resort to archaic methods, such as skimming cash from a family business, purchasing physical bearer bonds, or opening a secret savings account at a local bank using a post office box. In the highly digitized, connected environment of 2026, those primitive methods have been completely replaced by sophisticated digital manipulation, which in turn has forced the family law framework to deploy cutting-edge digital forensics to uncover hidden wealth. Consider the step-by-step reality of modern asset tracking. When Richard decides he wants to exit the marriage, he might attempt to quietly divert marital income into decentralized finance protocols, purchasing mainstream cryptocurrencies, or moving funds into privacy-focused digital tokens across various non-custodial wallets. He assumes that because these assets exist on an anonymous, decentralized blockchain network, they are entirely shielded from Eleanor's legal team. This assumption is a critical error. In 2026, forensic accounting firms specializing in domestic relations utilize advanced proprietary algorithmic tracking software to conduct complete metadata audits of a household's entire digital ecosystem. The investigation begins with the comprehensive forensic imaging of all shared and personal electronic devices under strict court-ordered electronic discovery mandates. Specialized hardware extracts deleted data directories, temporary internet cache files, and cloud application synchronization logs. If Richard accessed a digital asset exchange from his personal smartphone or smart laptop even once, the software flags the specific IP address logs and session tokens. Forensic analysts then cross-reference these digital timestamps with traditional bank statements, looking for microdeposits or outbound electronic fund transfers that match the exact moments of digital network activity. Once a specific public wallet address is identified on the blockchain, the legal team applies advanced cluster analysis to trace the flow of tokens through various smart contracts, exposing the hidden capital and presenting an unassailable data model to the family law judge. Furthermore, the proliferation of the Internet of Things and smart home automation has transformed everyday consumer devices into critical digital witnesses within modern divorce litigation. Smart thermostats, connected security cameras, automated toll road transponders, and GPS location history logs from modern electric vehicles generate a continuous time-stamped geographical matrix of an individual's physical movements. If a spouse denies the existence of an undisclosed secondary luxury property or denies meeting with an unlisted financial broker, a forensic subpoena of their vehicle's automated navigation logs can instantly dismantle their testimony by proving a repetitive pattern of physical visits to the exact coordinates of the asset. This absolute level of data surveillance has completely stripped privacy away from the dissolution process, transforming the modern trial into a highly technical battle of data scientists and forensic computer specialists. The extreme financial and emotional toll of navigating this high-tech administrative gauntlet has pushed the American population toward a massive breaking point. As couples realize that traditional adversarial litigation in the 21st century can easily consume tens of thousands of dollars in expert fees, destroy family relationships, and lay bare their private digital lives for public record, a powerful counter-movement is beginning to completely reshape the structural endgame of the typical divorce journey. How are innovative legal frameworks, automated online mediation platforms, and the rise of collaborative family law structures stepping in to permanently bypass the traditional courtroom model? What happens when artificial intelligence systems begin directly analyzing household balance sheets to generate automated, legally binding property distribution models without human bias? And as we look toward the final chapters of this demographic evolution, what does the future look like for the American family structure when the legal contract of marriage itself becomes completely decoupled from the traditional boundaries of the state? To answer this question, we must analyze the massive institutional migration away from traditional courthouse litigation toward private, decentralized systems of dispute resolution that are redefining the endgame of the American marriage in 2026. For generations, the standard path of marital dissolution was inherently public, adversarial, and deeply anchored within the state judicial apparatus. A husband and a wife hired competing legal advocates whose structural incentive was to maximize conflict, utilize aggressive discovery tactics, and bill thousands of dollars in hourly fees to secure a definitive victory in front of a state-appointed judge. However, historical trends over the past 2 decades reveal a profound systemic exhaustion. The extreme financial drain, coupled with the permanent psychological trauma inflicted upon children and the complete exposure of private digital lives in public court records, has driven a massive demographic shift toward alternative dispute resolution, or ADR. This movement is systematically bypassing the courtroom model and replacing it with highly sophisticated, private contractual frameworks. Let us break down the exact mechanics of this structural alternative, beginning with the institutionalization of collaborative family law. Collaborative divorce represents a radical departure from traditional litigation because it fundamentally alters the underlying legal contract between the attorneys and their clients. In a standard high-conflict scenario, a family law attorney stands ready to instantly pivot to an aggressive courtroom trial if negotiations stall. In a collaborative framework, however, both spouses and their respective attorneys sign a legally binding document known as a participation agreement. This agreement explicitly mandates that both lawyers are contractually barred from ever representing these clients in a contested court battle. If the collaborative process breaks down and either party decides to file an adversarial lawsuit in a state court, both attorneys are instantly disqualified and must immediately withdraw from the case, forcing the spouses to hire entirely new legal teams and reset their financial expenditures to zero. This participation agreement creates a highly effective economic and psychological incentive structure. Because the attorneys cannot use the threat of a courtroom trial as a tactical leverage point or an automated revenue generator, their entire professional focus shifts toward creative, mutually beneficial problem solving. The step-by-step process of a collaborative journey replaces the hostile courtroom with a structured series of multidisciplinary team meetings. Instead of a single judge imposing a rigid, formulaic decree from the bench, the couple utilizes a shared network of neutral professionals, including neutral financial specialists, child specialists, and divorce coaches. The neutral financial specialist acts as a joint auditor, creating a singular, transparent spreadsheet of all marital and separate assets, analyzing tax implications, and generating long-term cash flow projections for both future households. The child specialist acts as an independent voice for the children, conducting private interviews and working with the parents to craft a highly customized, flexible parenting plan that evolves with the developmental needs of the family. This multidisciplinary approach strips away the winner-take-all dynamic of the traditional courtroom, converting a destructive legal battle into a structured transition strategy. Imagine if we look at a modern case study unfolding in the year 2026, involving a couple named Marcus and Sarah living in Charlotte, North Carolina. Marcus is an executive at a major financial institution, and Sarah is a specialized medical director. Together, they have accumulated a complex marital estate worth millions of dollars, including corporate stock options, commercial real estate holdings, and private school tuitions for their 2 young children. Under the traditional judicial model, their separation would inevitably trigger a multi-year courtroom battle, costing upwards of $100,000 in competing expert fees and laying bare their private corporate finances for public consumption. Instead, Marcus and Sarah opt for an entirely modernized, AI-driven private mediation framework that has gained widespread traction across major American metropolitan hubs in 2026. The execution of this advanced technological journey bypasses human emotional volatility through the implementation of predictive algorithmic modeling. Marcus and Sarah log into a specialized, secure online dispute resolution platform that is legally integrated with their verified financial data feeds, tax records, and real estate valuations. The artificial intelligence architecture ingests this massive pool of raw financial data and immediately cross-references it with hundreds of thousands of historical family law cases, local judicial rulings, and appellate court outcomes within their specific geographic jurisdiction. Within seconds, the algorithmic model outputs an exhaustive diagnostic report detailing the precise mathematical boundaries of how a local family court judge would likely distribute their property and calculate spousal support based on current historical trends. Equipped with this objective, data-driven reality check, Marcus and Sarah enter into a private, remote mediation session managed by a highly skilled neutral facilitator who utilizes the software to run real-time scenario simulations. If Sarah requests to keep the primary marital residence while surrendering her claim to Marcus's corporate pension, the algorithm instantly calculates the precise long-term tax adjustments, inflation projections, and asset equalization payments required to keep the division mathematically equitable over a 20-year horizon. This level of rapid automated transparency strips away the traditional posturing and endless legal positioning that historically dragged out cases for years. Marcus and Sarah can complete their entire property distribution and parenting agreement within a matter of days, completely independent of the state's backlogged judicial calendar, and submit a finalized, mutually agreed-upon package to a judge for a routine administrative signature. The demographic data tracking this evolution indicates that in 2026, less than 5% of all filed marital dissolutions in the United States ever reach a contested courtroom trial. The family court has increasingly been relegated to a simple bureaucratic rubber stamp for private agreements forged in the crucible of mediation, collaborative law, and algorithmic arbitration. This systemic shift has completely rewritten the professional landscape of family law, forcing traditional trial attorneys to reinvent themselves as conflict resolution consultants, collaborative strategists, and technology-adept negotiators. Let us examine the specific algorithmic parameters that drive these 2026 online dispute resolution platforms. The software does not merely look at current balances. It applies advanced machine learning models to analyze behavioral spending patterns extracted from years of joint credit card statements and bank ledgers. If the algorithm detects an unusual spike in unilateral cash withdrawals or hidden credit applications in the months leading up to the initial filing, it automatically flags these transactions as potential dissipation of marital assets. This automated forensic capacity completely eliminates the traditional, expensive process of manual discovery, where paralegals spent weeks cataloging physical receipts and paper statements. The technology democratizes forensic accounting, making advanced asset protection and transparency accessible to middle-class couples who could never otherwise afford to hire a private investigator or a forensic accountant. In addition to financial modeling, these modern platforms are systematically integrating behavioral psychology into parenting plan development. When Marcus and Sarah utilize the platform to draft their custody schedules, the AI doesn't just offer a standard alternating weekend template. It requests inputs regarding the children's specific school calendars, extracurricular sports schedules, and the parents' real-time professional travel logs. The system then outputs an optimized, conflict-free custody matrix that minimizes logistical friction and reduces the probability of future scheduling disputes. If a conflict does arise post-divorce, the parents do not run back to court. They return to the digital interface, which uses automated smart contracts to resolve modification requests based on pre-agreed parameters, effectively converting family law into an automated utility. This technological efficiency is triggering a massive ideological shift among legal scholars regarding the very definition of the marriage contract. For centuries, Western jurisprudence viewed marriage as a tripartite agreement between the husband, the wife, and the state. The state dictated the age of entry, the grounds for exit, and the precise rules governing the distribution of wealth and children. In 2026, this tripartite model is rapidly fragmenting into a bipartite model, composed strictly of the two consenting adults. By utilizing comprehensive prenuptial agreements, private mediation frameworks, and digital asset tracking networks, modern couples are effectively drafting their own private legal systems, reducing the state's role to that of a passive registry clerk. This represents a monumental demographic realignment that is completely altering how wealth, property, and family legacies are transmitted across generations in American history. This privatization movement is laying the groundwork for a profound, long-term decoupling of relationships from the state entirely. As younger generations observe the immense complexity and potential hazards embedded within the state-managed legal contract of marriage, a growing demographic subset is choosing to entirely bypass state-sanctioned unions in favor of private, customized relationship contracts. These cohabitation agreements and private domestic partnerships utilize basic contract law to outline the financial rights, property division models, and mutual obligations of the parties without ever granting the state the automatic authority to intervene via family courts. This represents the ultimate evolution of the historical trajectory we have traced. An absolute return to relationship structures defined not by religious sacraments or state mandates, but by individual autonomy, data-driven planning, and private contractual agreements. This transformation marks a permanent departure from the rigid, punitive structures of the past, paving the way for a highly rationalized, data-driven approach to domestic partnerships. But as we prepare to close this exhaustive masterclass, we must confront the final, ultimate phase of this historical journey. What are the definitive macrodemographic projections for the remainder of the 21st century? How will the continuing collapse of the traditional birth rate, the hyperaging of the American population, and the complete institutionalization of artificial intelligence permanently alter the baseline survival of human relationships? And what is the final undeniable truth that emerges when we synthesize 250 years of the American divorce journey into a single predictive blueprint for the future of human love, family structure, and socio-economic survival? Synthesizing this 250-year evolution reveals a definitive trajectory. The American marriage has transformed from a rigid economic survival pact into an elite, hyper-rationalized legal option. When we look across the vast expanse of United States history, the journey of marital dissolution has never been static. It has consistently mirrored the shifting tectonic plates of macroeconomics, technological capability, and legislative philosophy. In the early days of the Republic, the structural barriers of coverture and legislative decrees kept the visible dissolution rate near zero, treating the family unit as an immutable block of state stability. The industrialization of the 19th century introduced the adversarial, fault-based system, turning personal domestic failures into public legal crimes, and giving rise to the earliest demographic waves of migratory escape. The late 20th century experienced the explosive liberalization of the no-fault revolution, which dismantled the moral arbitration of courts, unlocked decades of pent-up demand, and exposed the profound financial vulnerabilities of dependent spouses within a rapidly changing labor market. Today, in the year 2026, we stand at the precipice of a completely new demographic paradigm, where the lessons of this turbulent history have culminated in a highly protective, data-driven approach to human partnerships. To understand the macrodemographic projections for the remainder of the 21st century, we must analyze the profound structural stress being placed on the family law architecture by the dual forces of a collapsing birth rate and a hyperaging population. Demographic data indicates that the United States total fertility rate has remained consistently below the replacement threshold of 2.1 births per woman for decades, a trend that has accelerated sharply leading into 2026. This permanent contraction of the younger population completely alters the mechanics of the traditional family court system. For over 50 years, a massive portion of the judicial infrastructure was explicitly designed to manage high-conflict custody disputes, execute complex child support calculations, and enforce state-managed parenting matrices. As the proportion of households with minor children steadily shrinks over the coming decades, the focus of family law will inevitably undergo a massive structural pivot. Imagine a real-world scenario unfolding over the next 20 years involving a citizen named Ethan living in a highly urbanized region of the United States. Ethan belongs to a generation where single-child households and voluntary childlessness are the dominant statistical norms. When Ethan navigates a relationship dissolution in the mid-21st century, the legal battle will not revolve around school bus schedules, joint physical custody rotations, or the automated wage garnishments of the Title IV child support enforcement system. Instead, the legal and financial warfare will shift entirely toward the management and distribution of multi-generational eldercare obligations and highly abstract assets. Sociologists track this emerging crisis as the rise of the sandwich generation's dissolution, where divorcing couples must legally partition not just their accumulated wealth, but also the physical and financial responsibility for their hyperaging, long-lived baby boomer parents. The courts of the future will be forced to develop entirely new statutory frameworks to determine which ex-spouse retains the legal and financial obligation to support a former parent-in-law in an assisted living facility, creating an incredibly complex intersection of elder law, contract law, and domestic relations. This hyperaging demographic shift, frequently referred to as the silver tsunami, ensures that the phenomenon of gray divorce will remain a dominant statistical indicator for the remainder of the century. As medical technology extends the average human lifespan well into the late 80s and 90s, the calculation of marital longevity undergoes a fundamental psychological realignment. An individual reaching the age of 65 in the mid-12th century is no longer looking at a brief, predictable retirement twilight. They are looking at 25 to 30 years of active, independent life. Historical trends demonstrate that older adults are increasingly unwilling to spend these final decades in emotionally stagnant or financially incompatible unions. However, because a late-life dissolution permanently divides a retirement portfolio at the exact moment when the capacity for active labor is severely diminished, the long-term potential outcomes of these cases will continue to place an immense strain on the state's social safety net infrastructure, driving a massive political debate over the restructuring of Social Security auxiliary allocations and public healthcare subsidies. Simultaneously, the complete institutionalization of artificial intelligence and predictive algorithmic modeling is systematically stripping human emotional volatility out of the dissolution process entirely. As we observed in the evolution of modern online dispute resolution platforms in 2026, the traditional high-conflict trial attorney is becoming an endangered species. The future of family law is entirely automated, transparent, and transactional. When a couple decides to dissolve a partnership, the entire process will be governed by smart contracts deployed on immutable digital ledgers. The predictive algorithms will not merely evaluate past historical data. They will actively project future economic trends, calculating real-time adjustments for inflation, localized housing market fluctuations, and shifting labor market demands to generate flawless, automated asset distribution schedules that prevent either individual from falling below a sustainable economic threshold. This absolute level of technological optimization is triggering a profound cultural backlash that is permanently decoupling relationships from the boundaries of the state. Younger cohorts, having witnessed the systemic financial liquidations suffered by previous generations during the late 20th century divorce boom, are increasingly viewing the traditional state-sanctioned marriage certificate as an unnecessary, high-risk financial liability. The predictive blueprint for the future of human love is the absolute rise of the private relationship contract. In the coming decades, the demographic data will show a massive migration toward customized cohabitation agreements, decentralized domestic partnerships, and intent-based kinship networks that utilize basic contract law to outline financial expectations and asset division models without ever granting the state judicial apparatus the automatic authority to intervene. Marriage as a state-managed institution will increasingly become a historical relic, replaced by a fluid landscape of private, autonomous agreements tailored to the specific economic and personal realities of the digital age. This masterclass has traced the long, complex journey of how the American family unit has constantly adapted to survive the forces of history. From the absolute legal erasure of coverture to the automated, algorithmic surveillance systems of modern child support and digital asset tracking, the history of divorce is fundamentally the history of human freedom struggling against institutional rigidity. Understanding these historical trends is the single most powerful tool you possess to navigate the complex economic and social realities of the modern world, allowing you to view your personal relationships not through the lens of emotional rhetoric, but through the clear, analytical framework of data-driven history. But as the traditional state-sanctioned marriage contract dissolves into a landscape of private digital agreements and automated algorithmic utilities, a terrifying new legal and sociological question begins to emerge on the global horizon. What happens when these decentralized relationship contracts cross highly volatile international borders, clashing with the sovereign laws of nations that still enforce ancient, patriarchal, or highly punitive family codes? How will the rise of global remote work, digital nomadism, and international asset protection trusts create a massive, unprecedented conflict of laws that threatens to destabilize the global economic elite? Turn your attention to our upcoming investigative series, where we will cross international borders to dissect the high-stakes, multi-jurisdictional legal warfare of the global asset protection networks, investigating how the ultra-wealthy permanently shield their billions from the reaching hands of domestic family courts across the globe.